Welcome back. This is No Kings on the Hill. I'm Dr. Hill Law, your host, and I've got Joe St. Clair with me. He's just going to be in audio today. His doesn't have his camera. So before we begin, if you are new, hit follow or subscribe, like this video, and share it with someone who wants a clear understanding of law, policy, and power. As you see our website scrolling across the bottom of your screen, No Kings on the Hill with drlaw.com, please be sure to check it out where you can find links to all of our other socials, find previous episodes, and subscribe for free to gain access to our weekly blog, or subscribe to one of our 3 paid tiers to support us bringing you daily episodes of more live interviews as we did last week from CPAC 2026. Supporting our content also gets you a chance at being a guest host once a month, daily subscriber-only lives, and Discord chats, along with the chance to choose the next topic we cover. Also, please leave us a review to let us know how we are doing. Today, we are taking the full measure of the Supreme Court's spring term, the constitutional questions, the political fallout, and why the decisions landing this season will change how immigration, ballots, and states govern elections. We'll spend the bulk of the hour on the court's birthright citizenship case, and we'll fold in related fights over state ballots rules and with a particular attention to Watson v. Mississippi and Bost v. Illinois. We have audio from today's oral arguments to share, so stick around. We'll be right back with you after a word from our sponsor. And also after that, we may look at covering some of the Artemis launch today.
Heard of Q broadcast? It's taking the world by storm. People are cutting the cord to their high cable bills and moving away from streaming services like Netflix, Hulu, and others for something better. Q broadcast. For just $60 a month, you'll get access to every channel you could ever want, including HBO, Cinemax, and Starz. And the best part? There are no contracts, no hidden fees, and you're free to cancel anytime. With Q Broadcast, you can enjoy streaming live TV, movies, and top series on up to 5 devices at once. Whether you're at home or on the go, Q Broadcast makes sure your entertainment is always at your fingertips. Imagine being able to watch all your favorite channels from anywhere, anytime, without any restrictions. We're talking about thousands of movies, hundreds of TV series, and a huge library of live channels, all in one place. And don't forget video on demand and pay-per-view events. Those are included at no extra cost, so you'll never miss a big event again. Now, take a second and think about your current cable bill. You're probably paying anywhere between $100 and $300 every month, locked into long-term contracts and hit with surprise rate increases. With Q Broadcast, that's a thing of the past. It's just $60 a month. No contracts, no extra fees, no hidden costs, and no price hikes. Why juggle multiple subscriptions like Netflix, Hulu, and cable when Q Broadcast gives you everything you need in one convenient package? People everywhere are switching to Q Broadcast, saving money and getting more content than ever before. So, what are you waiting for? Click the link in the description and sign up for Q Broadcast today. Just $60 a month, no contracts, no hidden fees. It's time to take control of your entertainment and start streaming smarter.
All right, so welcome back. I'm going to get through my monologue, and then we'll probably be about time for the Artemis 2 launch. All right, normally when we talk about what the Supreme Court is doing, we say they're deciding cases. They're deciding precedent. They're deciding the law. Well, in this year, they are deciding on a structure. They are deciding the structure of citizenship, the structure of elections. All right, that's what we're looking at this year. And the structure of who has access to the courts and access to suing for those elections. First up, obviously, we have birthright citizenship. Birthright citizenship, as we know it today, is defined by the 14th Amendment, more specifically by this specific line. All persons born or naturalized in the United States and subject to the jurisdiction thereof. Now, the controversy hasn't centered on the first portion of that sentence. It has always centered on the last line of the sentence, which is subject to the jurisdiction thereof. Now, Senator Jacob Howard, the congressman who actually wrote that sentence as part of the drafting of the 14th Amendment, said at the time that being subject to the jurisdiction meant complete and full jurisdiction, not partial or temporary allegiance to the United States. Senator Lynn Trumbull, likewise, when debating the Civil Rights Act and crafting the same line in the 14th Amendment, said jurisdiction would mean that you didn't show allegiance to anybody else. Notice what they didn't say. They didn't say being born on American soil automatically makes you a citizen. No, they talked about jurisdiction, sole allegiance, exclusive sovereignty. Today's citizenship is viewed as essentially automatic. The question the court must decide is whether that interpretation is an unlawful expansion of the original structure and whether the executive branch can correct that unlawful expansion through executive action. Which brings us to Trump's executive order. The legal argument for that theory is structural as well. Citizenship isn't defined by place of birth. It's defined by jurisdiction, sole allegiance, and exclusive sovereignty. Again, listen to those words. Think about it for a second. This has nothing, the founders were worried about divided allegiance. Okay, in Federalist number 42, Madison wrote that having different naturalization laws would lead to citizens owing conflicting allegiances to two states. He understood that allegiance, the core of citizenship, had to be tied to a sovereign nation or a sovereignty. Place of birth matters, yes, but the question of birthright citizenship goes further to ask, is citizenship determined by territory, or is it determined by the sovereignty, by law and politics? All right, so that's what we're looking at on this one, which is the question the court will hear, and that's obviously what they debated today. Now let's talk about Watson v. Mississippi, because this is where constitutional law meets nuts and bolts reality. Watson poses a straightforward question: what is election day? It questions this with absentee ballots. It's saying now in Mississippi, election day is multiple days. Now, is election day date certain? Ballots must be received and counted by that date? Or is it a movable deadline? Ballots can continue to arrive and be counted after election day, which is what Mississippi argues. For much of our history, the answer was clear. Congress had set election day, period. Even in the middle of the Civil War, our nation's bloodiest conflict, America still observed the concept of a specific election day. Why elections need finishing lines? They need clarity. They need public confidence. If you move the goalpost, if election day never truly arrives due to postmarks or late arrivals, then the very idea of an election day starts to lose meaning and strikes doubt on the results. I'm not saying those arguments don't exist on the other side, access, participation, but from a structural standpoint, what we're really talking about is this: can you run a race with a moving finish line? Does something lose legitimacy if you don't know when it ends? That is the question Watson presents to the court. And finally, the biggest structurally impactful election law case of the term, which has already had the decision decided, was Bost v. Illinois, which kind of went through there quietly. Nobody's really talked about it, but it's major. You might be wondering why it is the biggest electoral structural shift case. Well, it's simple. This isn't a case about ballot counting. Bost is about access to the courts and the ability to be able to sue or challenge law. Previously, our standard for who has standing in election cases was limited. Essentially, in most cases, a candidate or a plaintiff needed to wait until after an election to show they've been consecrately and actually harmed. Literally, you had to lose first, and then you had to prove injury before you could actually claim or charge or challenge any rule or regulation in elections from that state. Bost upended that. The court rightly noted that sometimes waiting until after an election for relief is meaningless. There's no way to fix it after the fact. So what they did a couple months ago when this was ruled was, under Bost, a candidate can show standing prior to an election. Now the only way they need to show standing is that they're actually a candidate, by proving their ability to have an honest election. All right, so that's where this is going to be a major impact, but nobody's really paid attention to. By the implementation of a law or ballot procedure, candidates now have greater access to the courts before an election instead of having to wait till after, like we saw in Bush v. Gore, to try and fix what they see as unfair rules. Previously, this kind of lawsuit would typically be barred until after voters voted. Breaking that down, now we don't have to wait till after. Now we have election law litigation that's just from being reactive to proactive. Instead of having to wait till after it, now they can actually go after the laws when they've changed the beginning, which will stop states from trying to go out and just change rules and regulations right in the middle of an election, because now they can be challenged and they don't have to wait until after the harm occurs to go ahead and challenge that. So now lawsuits can be filed ahead of time and get this before the harm occurs, which was not previously what had happened in anything doing with election integrity. So some people may ask, what does this mean for election integrity standpoint? Essentially, it gives more suits will be filed, and it gives the congressional members, either party, more chances to challenge pre-election laws or laws dealing with ballots that they believe are unfair or unconstitutional. Courts can be asked to preemptively challenge election laws before election day. Now, obviously, advocates, which I am one, this is great. It allows candidates to protect themselves and uphold election integrity. Obviously, the opponents will say that it's going to cause too many election cases and that it's ridiculous and it allows for more partisan strategy lawsuits, which it really doesn't, because you still have to file a lawsuit for something that's actually unconstitutional or illegal. So Bost has fully changed the landscape when it comes to challenging election laws. It decreases the barriers for candidates to go into federal court for election cases. Combine that with what we're seeing else in the Supreme Court with Watson v. Mississippi, which is the definition of election day, and how it is, and we have in the Constitution. A country that's trying to figure out what election day is, which is sad that we've got to try to figure that out when it's already defined clearly in the Constitution, and that's not up to the states to change. I mean, a legal precedent allows folks to argue that all go into court before election day. So it's gone. What are you talking about? Rulemaking in a machine like Optimus? Okay. I mean, am I American? Yeah, I'm American. Now, citizenship obviously determines who is a part of the political community. Watson v. Mississippi determines what a vote is and whether election day is one day or a moving deadline. And Bost v. Illinois determines who can challenge elections before they take place. Look what you get when you link all three. Who has access to our democracy, who has a say in our democracy, and who gets to manipulate our democracy before it even begins. So I'm looking at, we got about 10 minutes to the thing, so I got a little bit longer to go. But today we're focused on the last one, but realize that that's because of the first two. Because this isn't piecemeal change we're looking at. This is a complete overhaul if the Supreme Court actually rules in favor of the rules in Trump's favor versus in the state's favor versus the challenger, Barbara. I mean, once upon a time, challenges to elections occurred after the fact, but candidates can now file suit pre-election, asserting that the election itself is compromised. And while that changes the timing of lawsuits, that changes how campaigns, it also changes how campaigns are run. That changes our democracy. But when you zoom out, we're really talking about the court determining what we're doing, who is covered by the law and who is protected by the law. So, and whose votes will actually be counted by the law, and who has standing to upset that law beforehand in incremental change. I'm trying to see what we're at on the launch. So, I mean, think about how our constitutional system derives legitimacy. Are you in or out of the club? It's simple as that. Do you know how you're treated? Do you know, can you access justice? It goes strictly into that. So I don't think I have really much left on this, and we'll go to this. Once I get through covering the launch, I will get Joe up here and we'll talk about it. We're going to play some of we will play some of today's oral arguments on the audio from it. I do have that. So once we get there, I got about 10 minutes. Actually, I'm going to go ahead and see if I can get Joe up here because we still got a little bit of time before the launch happens. Right now, it looks like the time's not counting down. So I don't know if they've paused it or if they're still going to launch. I guess we'll see. I'm trying to unmute yourself, Joe, because it still has you muted on my side. But let me see if it. Okay, see, there we go. I got you.
Yeah, because now it says I'm in the show. So before it did not say I was in the show. So that's why I couldn't talk.
Yeah, that's weird. All right. Yeah, I don't know. When you were asking me earlier on the phone, do I think how the Supreme Court rule? We always know that a lot of times, yes, we can glean how the Supreme Court's going to rule by the questions they ask or by the statements they make, but not always. But like I was talking about earlier, if you actually they claim the majority of the conservative justices claim to be textualist or originalist, and they're going to go textually and go based off the originalist or the textual intent of the law, then they need to actually go based on how the jurisdiction thereof was actually defined and
Right.
based on the
Well, I
people who
don't.
actually wrote that.
Well, so no, I agree with you, but I think the only person in the court who's really just going to rubber stamp anything is, Jackson, where she's just going to rubber stamp dissents without actually making a real argument. So maybe they are going to side with Trump, and maybe their line of questions, towards Trump's attorneys, and the reason that they're being so critical is because if they do end up, overturning precedent, they want, you know, to show that they did their due diligence. But at the same time, no, I was listening today, and they are following originalism, but obviously there's a fight over the definition of jurisdiction. There's a fight over definition of domicile, and
Yeah,
it is
and the
it
thing
is
is, if
true
you
that
look
the
at it,
DOJ attorneys are switching. They're kind of cherry picking definitions based on different years.
but if you
So
look back at when the 14th Amendment was written, that was what the congressional member that actually added jurisdiction thereof to the Senate specifically said that it was dealt with sovereignty and that you had full that you had given full your full allegiance to that nation, to the United
right,
States. So if you're not, in other words, you have to be a citizen, already be a citizen of the United States in order for you to have the birthright citizenship, because it was written to protect the children of former slaves.
right, and
It had
I also think Trump's presence, you know, I think it might backfire on him, honestly, because even the moderate conservatives in the court have already shown that they're gonna vote the way they want to vote and how they feel led to vote, as opposed to being pressured by him. So I think, I mean, they're human beings. They're supposed to be above that sort of thing. But at the end of the day, we saw some of the most liberal opinions come out of the civil rights court, and they were facing protesters and threats of violence. So SCOTUS is just as much. They can be pressured by the president, but I think it might backfire. I don't know. I hope not.
I don't think he went there. I don't think he went there for pressure today. I think he just went there because he wanted to hear it in person, because it's such a big historic argument and such a big historic oral argument as far as what this decides. Now they could come out and say, "Hey, we do agree, but this can't be done by executive order. This has got to be done through either a challenge outside, or it's got to be done through the Constitution, kind of, or through Congress, kind of like they did with because of Chevron deference being the Chevron deference being ended, just like they did with the case for the tariffs and the specific legislation that he was using. They didn't say that that Congress hadn't given them the ability to issue tariffs. They were just saying that that specific bill or piece of legislation he was using did not say the specific words of tariff, tax, or revenue in it. It said embargo. So it's saying that, okay, the usual where an agency would have said, well, lesser or, they say embargo, but we could do lesser or. So since now that deference doesn't go on an ambiguous piece of legislation like that, now it doesn't, that ruling that deference doesn't go to the agency. It's ruled by the court. So the court says, no, that's not it. And they could do the same thing here. They could say, hey, it's no longer, Chevron deference no longer falls to the agencies or executive. It falls to, this would have to be something that would be changed by by Congress itself. But honestly,
Yeah, that could be the case. I think I just saw a breaking headline that they reached a deal to Senate to fund Homeland Security. I don't know if you got that headline just now. But
Well, I know they were working on run. I know the Senator John Thune had stated that he was going to run the DHS funding bill through whatchamacallit so they could bypass the filibuster.
reconciliation.
Yeah, they're going to run it through reconciliation so it can bypass the filibuster and not have to worry about that versus running it through the appropriations bill. So it gets done, and so they don't have to do that, which honestly they should have attached the SAVE Act to it, because I don't know if you saw the executive order that President Trump signed yesterday on ensuring citizenship verification for mail-in ballots. That literally follows a lot and kind of in line with what I stated of what needed to be added to the SAVE Act back when I did the episode on the SAVE Act and election integrity there, that I stated that we needed to, within the confines of the Supreme Court ruling for Constitution of being able to control chain of custody and stuff on federal elections, which similar is what this executive order does. But even without birthright citizenship necessarily going in our favor, which obviously it's a historic ruling, it'll be historic either way it goes. But the Watson v. Mississippi, that ruling kind of goes in line with Bost v. Illinois, even though Bost v. Illinois ended up only got settled on the standing aspect of it, which was still historic in itself because it totally changed the definition of how you can file for any grievances with election law or ballots or anything like that. But now, and it was the same argument. It was where in Mississippi, it says they'll take absentee ballots up to like 5 days after the election and count them. Illinois stated that as long as the absentee or mail-in ballots were postmarked by election day, that they would take them they would count them up to like 12 days later. But if you actually go back to one of the arguments that that Judicial Watch, which are team attorneys that argued in this, because I actually spoke to one of the attorneys that argued Watson v. Mississippi, or prepared the brief and the arguments for it at CPAC this last week. They looked back to how even during the Civil War, they required the ballots to be to their precincts and counted on election day. And you're talking, this is back when going 20 miles on a horse could take 2-3 days. And to say that somehow today we need to extend election day when the Constitution specifically states that Congress defines that and has that ability on federal elections. And then in the actual legislation, it states election day is election day, not the extension of 12 days after.
Right.
I guess we'll see how it goes. But I mean, I think that one I see going in the favor of they're going to define election day. It'll change
I think Trump will obviously win that one. I have zero idea how it's going to go, with the birthright citizenship case. I don't know.
Well,
I only listened to about an hour of it today, but I don't know if you listened to the entire thing. Did the case of like Chinese billionaires essentially using IVF and surrogates as a mechanism to get all their future heirs American citizens, was that brought up? Do you know?
I can't remember exactly. I've got the full. We've got a couple minutes to come to it, so let me pull this up and let me get the. Is that the wrong one, or is it this one? Actually, I've got the full slide pulled up.
I also noticed the government, the attorneys who, I think it was for the ACLU, the ones that essentially are defending birthright citizenship. I noticed that they were also hearkening back to English common law. So there's the whole battle over definitions. But I do agree overall that if you look at the context of when the 14th Amendment was passed, there's a reason it was passed at the end of the Civil War. So
this literally states the Citizenship Clause was adopted just after Civil War to grant citizenship to the newly freed slaves and their children, whose allegiance to the United States had been established by generations of domicile here. It did not grant citizenship to the children of temporary visitors or illegal aliens, which I can play. Where did it go to? I actually had the audio. I have the audio up. It should be on this page
Well,
go
then,
to this.
then their counterpoint was there was no immigration laws. There was no such thing as an illegal immigrant or visitor.
I'm trying to get to the at least to the minute mark or something. Kind of hard to.
Where'd you go? Are you here?
Yeah, I dropped.
Are you still on mic? Are you just
Can you
reading?
hear it?
I'm not hearing you.
Hold on a second. It should be going through. I shared when I
I'm
shared it,
not
I
hearing
shared
you.
it
Maybe the audience can.
because I shared it with the screen share. Let me redo the screen share again because I shared it, did screen share, and I shared the file. I shared it with audio, so it should be playing the audio system. It shows that it shows the mic on here. It says mute screen audio, unmute screen audio. So let me know if y'all can hear it. It's pretty much going through what I read was that it says in 1884, this court recognized that subject to the jurisdiction means owing direct and immediate allegiance. The clause thus does not extend citizenship to the children of temporary visa holders or illegal aliens. Unlike the newly freed slaves, those visitors lacked direct and immediate allegiance to the United States. For aliens, lawful domicile is the status that creates the requisite allegiance. And the text of the clause presupposes domicile. For decades following the clause's adoption, commentators recognized that the children of temporary visitors are not citizens and illegal aliens lack the legal capacity to establish domicile here. Unrestricted birthright citizenship contradicts the practice of the overwhelming majority of modern nations. It demeans the priceless and profound gift of American citizenship. It operates as a powerful pull factor for illegal immigration and rewards illegal aliens who not only violate the immigration law, but also jump in front of those who follow the rules. And I see what page that one is, 5. Yeah, no, that's the right page where I'm at. So people can see the right page. They also jump in front of the line. It has spawned a sprawling industry of birth tourism as uncounted thousands of foreigners from potentially hostile nations have flocked to give birth in the United States in recent decades, creating a whole generation of American citizens abroad with no meaningful ties to the United States. I welcome the court's questions, Justice Thomas. General Sawyer, before we get into the broader national issues, would you start with Dred Scott? Dred Scott was a case about state citizenship. It was a diversity case. And of course, we know what Chief Justice Taney did with that. How does the Citizenship Clause respond specifically to Dred Scott and answer or changes or corrects its answer as to citizenship? The other point is the Citizenship Clause refers not just to national citizens, but also to state citizenship. Are we to have two different definitions for those? It's one word, citizens of the United States and citizens of the state wherein they reside. So as you begin, I'd like you to go back at the beginning and be more specific about the answer. And I want you to explain whether or not those two definitions are the same or related and what citizenship is based on, is what they said. So Sawyer's reply to Justice Thomas is, I'll maybe start by addressing Dred Scott. As you alluded to, the fact Dred Scott, imposed one of the worst injustices in the history of this court. And it led in the court, and it led to the outbreak of the Civil War. It's very clear in this court, in all of its early cases, interpreted the 14th Amendment, said, the one pervading purpose The main objective of the citizenship clause is to overrule Dred Scott and establish the citizenship of the freed slaves. If you look at the debates in the congressional record and discussions surrounding the adoption of the citizenship clause, what you see is a very clear understanding that the newly freed slaves and their children have a relationship with domicile. They do not have a relationship to any foreign power. For example, there's a comment where he says, look, people have been here for 5 generations and clearly have no relationships to any foreign African potentate, or have a relationship of allegiance to the United States. And that reinforces our point that allegiance is what the word jurisdiction means. It doesn't mean regulatory jurisdiction or some sort of being merely subject to the laws. They're talking and they're thinking about it in those debates about allegiance. Now, as to your second question, if you look at the text of the clause, we believe there it says, born in the United States, born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the states of which they reside. So there's a constitutional guarantee that applies to both federal or national and state citizenship. And the key point we make there is that the word reside, if you look at, for example, section 1473 of Justice Story's commentaries was understood to mean domicile. So when they say subject to the jurisdiction thereof, and then they go on to say you're a citizen of the United States and the state in which they reside, the very text of the clause itself presupposes that the citizen is domiciled in the United States. If they're present in a state at all, they reside there. Reside means domiciled in the Constitution, and we think that strongly supports our interpretation. It's textual evidence of our domicile-based theory of jurisdiction. Well, starting with that theory, you obviously put a lot of weight on subject to the jurisdiction thereof, but the examples you give to support that strike me as very quirky. Children of ambassadors, children of enemies, during a hostile invasion, children on warships, and then you expand it to a whole class of illegal aliens are here in the country. I mean, it goes through, but I don't know. There it kind of looks like they're in favor of it, but it goes down the line. Justice Thomas and Justice Alito look like they're in favor of it, but who knows? I guess we'll have to see. But here we got 3 minutes till the launch, so I'm gonna add it.
I got you back on audio. I don't know why it cut out earlier.
Yeah, but I'm going to add this to the stage because we got the launch back up.
Coming up in just a few seconds, we're going to get that thrust vector control actuator test. This is a gimbling of
It's crazy how many people are going to say that this is fake.
Yeah, well.
There are the 4 RS-25s.
Let's hope it goes well.
3 of them.
Because they say, we can't get past the Kepler belt, but yet they're going to be broadcasting live internet from this ship the whole time, and you're going to be able to see it on telescopes. The only thing that I think sucks is why didn't they just use the Starship that's got like 20 stories high versus this little bitty
now we're going to start
ship that's no bigger than a
from
big
both the upper stage and the lower stage of the rocket.
Not bus, but I mean a mini, like a big van.
Taking ground power away and now going to battery power.
That's how little room they have.
I have no idea.
Go for upper stage to internal power.
Just hope it goes well.
All right, power is removed from the rocket's upper stage.
I mean, it already went once.
CPS, and it's been switched
they already
to battery.
launched it.
Same milestone.
And this one has an escape, a way to escape for the thing to escape if there's something that happens.
The 4-person Artemis 2 crew is
the Artemis
miles away from the
top
moon.
end can
and if all
separate
goes well,
from
they
the
will fly by it in
rocket.
6 days.
I know it's off of our topic, but this is history in the making. It's like
all right. There's the rocket's core stage, which houses 3 flight
crazy
computers.
To think
it's
that
now
we're finally going back
power.
to the moon with a human, with actual people on
there's
the
no more hold time
ship.
because there's no more margin on these batteries. So we would have to recycle back to T-10 to recharge if we had a hold.
Looks like the sky cleared up perfectly for this. Looks beautiful out there.
1 minute.
Where's that launching from?
Right now, the rocket
Cape
does not
Canaveral.
know what the T0 is, but coming up at T-10,
I wonder if I can go. I wonder if I
control
can go look
shifts
outside
from
and see
ground
this.
launch sequencer to the rocket's onboard
What?
autonomous launch
I'm in
sequencer,
Orlando.
ALS. The rocket will
Oh,
count itself
tonight,
down.
go
But
outside.
honor any holds.
I don't
that
know if you'll be
come
able to
from
see
the
it from
ground.
Orlando, but if you were like
Now,
Daytona
shortly after
Beach,
liftoff, Houston will take
tonight
control.
the whole sky
of the
would light
rocket,
up like a
and my colleague
neon
Gary
blue
Jordan will
from
take
this
over
launch.
commentary.
I know. I saw it happen.
Go for
I got to see the last
Great call out.
space
The rocket
shuttle
is on
launch.
its own. 4 brave explorers ready to ride the most powerful
25.
rocket NASA has ever launched.
Believe it or not, this is more
Sound
powerful than
suppression
the
water is
original
flowing.
one, but it's a little shorter.
And here we go. 10, 9, 8, 7. RS-25 engines lit. 4, 3, 2, 1.
They're launching the rocket. We might be able to see it.
And liftoff.
You'll be able to see
The
it
crew
from
of Artemis
Orlando. You'll be
2
able to
now
see it go in
bound
the
for the
sky.
moon.
Once it gets
Humanity's
up, you'll
next
see it in
great
there.
voyage begins.
You'll be able to see a streak go through the sky from Orlando if you don't have any trees
Good
in your
roll
way.
pitch.
And depending on which way they
Roger, roll pitch.
I could see it. I could see it.
Flight of integrity.
Hey, look, they launched a rocket outside.
Yep.
Integrity, AMT high.
I got to watch it from Daytona.
On time,
Straight.
passing 30 seconds.
And in between the Daytona and the land side where you could actually, you're looking straight at the Space Coast.
If I could turn my camera around, I would show you.
Integrity, 3 miles in altitude. Traveling more than 1,200
Still
miles
doing
per
it.
Yep.
Yeah.
I told you could see it from there.
So there, you know it's real.
Yep. Well, and all the people that are actually watching it too. They'll try to say, "Oh, it'll stay in the circulation around the Earth.
Mission
It'll
last
never
time,
leave Earth's
passing
orbit."
1
But the
minute.
thing is you'll be able
Approaching
to look. You'll be able to use.
On, possibly on.
You will be able to use telescopes to see when it leaves Earth's orbit.
Have you the same?
You would see it just like you see
Communication
a
signal transport confirmed
just
as
like you
integrity
see,
and its crew go supersonic. Approaching 90
satellites,
seconds into
you
the
would
Artemis
see
2 mission.
the Artemis
Integrity is
2
14 miles in altitude, 8 miles
capsule.
downrange, traveling more than 2,600 miles per hour.
That's pretty cool. Nice.
Yeah, and wait, you might be able to see it tonight if it's anything. If this is anything, the same mixture that they had when I watched the last space shuttle launch. I was in
1
Daytona
minute, 50
Beach,
seconds
and
of
like
mission
that
last time,
night, the
standing
whole
by for
sky,
main
there was
engine
this
throttle
big,
down
huge,
to
like neon
85%,
blue cloud in the
solid
sky.
rocket booster separation expected at the 2
was
minute, 9
cool.
second mark.
It looked really cool. I don't know if this one will do that or not.
See throttle down?
That looked pretty. That did not look far away from me at all.
Confirmed separation.
Well, it's not. It's less than 100 miles.
Main engines throttling up, guidance converged.
Yep, there goes the 2 main rockets off. That's the only thing I understand is why NASA
Integrity,
did
guidance
2
converged,
reusable
performance
rockets.
nominal, upper stage RCS ready.
There's the curvature of the Earth, but oh, it's flat.
Yes, I'm trying to complete.
Well, they would say it's a flat disc.
2
They
minutes.
would say it's like an
45
oval,
mission
like
elapsed
an
time
oval
into the
disc.
Artemis 2 mission. Thrusters on integrity and upper stage confirmed in a
Yeah,
ready
what's going to
state,
happen
and
when they
service
take
module
pictures of
fairing
the dark
separation.
side of the moon? What's everybody going to say then? I mean, or that'll probably be the only time they lose internet
3
signal.
minutes
But
into
also,
the
I
flight,
think they've
integrity
actually set up.
49 miles in altitude,
I think they've
78
actually
miles
set up
downrange.
satellites on the backside of the
Now
moon so
passing
they
5,000
don't lose signal
miles
on
per
the
hour.
dark side like they did back in the 60s. All right, there goes the second separation. As they're up there where they can see out. Yep, there goes full separation.
Standing by for launch abort system jettison.
What must be going on in the minds of those astronauts? It's crazy.
Houston integrity, good last jettison, great view.
Yep, they can see. They can
Copy
see. space
jettison,
now.
Team Eco 8+02.
Yeah, that's exactly what I was just
We
looking
see
at.
the
That's
same on board, Stan.
so funny.
And Houston has you loud and clear on Tigris at the common line.
Wow.
Outstanding, Stan. We have you the same.
This
3
is the-
minutes, 50 seconds into the flight of Artemis 2. Wiseman, Glover, Cook, and Hansen cross the boundary to space with good comm checks. GPS signals acquired after last jettison now working on internal checks.
By
to
the end of
verify accuracy.
tonight, they will be 70 or
Flight dynamics officer
700,000
analyzed the time of main
miles
engine cutoff
or
confirmed
whatever
at 8 minutes,
kilometers
2
above
seconds,
the
time
Earth,
of
which
MECO.
will be past the Kepler belt and at the furthest distance anybody's gone, and how since the last time we went to the moon. And then by later on tomorrow morning, they'll be really close to Earth. They'll do a full day. I think it's a full day or around Earth, and then on the second day they do their last loop around it because they got to do 2 full rotations around to build up speed, and then they'll hit their exit velocity once everything checks out. And then
integrity, GPS processing.
They'll head to it, and they're supposed to be doing like live video feeds and stuff from the space shuttle.
And we have a beautiful moonrise. We're headed right at it.
But yeah, they're supposed to be doing live shots from it. But
approaching 5 minutes into the flight, Commander Reed Wiseman confirms he has visuals of his destination. GPS guidance, navigation, and control software finishes internal checks and sends to navigation channels.
Yeah, so now they're just getting into full
integrity, 3-engine press.
Now they're getting into their full orbit.
3-engine press.
On time, now passing 5 minutes, 20 seconds of mission elapsed time into the Artemis 2 mission. At this point, 3 good main engines are all that's needed to carry integrity to a nominal main engine cutoff target. Though at this time, we're seeing 4 good engines here in Mission Control Houston. Integrity, 75 miles in altitude, 330 miles downrange, approaching 10,000 miles per hour.
Yeah, that's crazy. It's crazy to think that we're finally going back to the moon after 70 some odd years.
Integrity, looking good at 6 minutes.
I know it's kind of off of our law and policy or constitution, but something you kind of can't miss. It's like
good trajectory.
History of our time. The next Artemis 3 will be them actually landed on the moon.
Soon report the shutdown plan to Flight Director Judd Friedling, expected at the 7-minute mark.
Well, I don't even know how they do the learning.
78 miles in altitude, 460 miles downrange.
Well, see, right now they still got the big rocket connected to them. So, once they get a little bit further out of Earth's atmosphere, when they'll be higher than what the space shuttle or the space station would be, that's when that big orange rocket will separate off. And then they'll have just their 3 or 4 little rockets on the backside of the actual the bottom side of the capsule that they're in, and then the solar panels will deploy. So yeah, it's crazy to see, and it's kind of almost in the same aspect that in the 70s. Obviously the first trip to the moon didn't land on the moon. It was like the second or third trip that went to the moon that actually finally landed. So the first couple obviously weren't manned. They had a chimp in it. Obviously this first one, because we didn't need chimps today, because obviously the amount of technology and instruments and everything, that type of technology we have, we sent all that in the first trip to make sure that it was the radiation was well within safe limits and everything and all that, making sure that everything worked, oxygen sensors, oxygen did. And that's what they'll do this time, is before they actually jettison them slingshot around Earth to go and leave Earth's gravity to get to the moon, they'll ensure that they have everything's working right, that all their oxygen systems and everything's working before they get to the point where there's really no point of return until they've gone around the other side of the moon and slingshotted back towards Earth, which is like 280,000 miles, I think is what they said that will be right. They'll be doing. Okay, so yeah, they just separated from the orange.
Integrity and nominal MECO core stage separated.
Yeah, so now it's just this little white part up there.
We see the same on board, Stan.
Because now they're about to separate these two, unless that's actually
8 minutes, 40 seconds into the flight, we have a nominal main engine cutoff heading in the right trajectory on the way to swing around the moon. Core stage has separated, done its job. The Space Launch System upper stage, the Inner Rim Cryogenic Propulsion Stage, or ICPS, still attached to the Orion spacecraft.
Yeah, it's just crazy to think that top part's
9
where
minutes
they're
of mission
in.
elapsed time.
What's crazy is that how quickly we went from
Jeremy Hansen, now in orbit
the
around
horse
at the
and
beginning of
carriage
their journey
to this. It's just insane.
Yep. 8 minutes and they're out in outer space.
Integrity Houston, looking ahead to PRM numbers so far per the pad.
What's crazy is they have to launch at certain times in order for the calculations to work for them to have the speed to make it.
Numbers for the pad.
Now, obviously, the whole point of Starship is Starship doesn't need to launch whenever because it'll be able to relaunch.
Now reminding the crew that the
it'll be able
perigee raise maneuver time of
refuel in
ignition
space.
is as expected prior to booster.
It'll be able to refuel in space and then actually relight its engines and be able to use its engines to go fast enough while it's in space. And that's the whole point of Starship. I don't know why NASA just doesn't launch once Starship's ready, they don't just launch the astronauts from Earth on Starship to the moon instead of NASA launching theirs and then Starship launching to the moon. And then whenever they get to the moon, having Starship connect with the lunar module, the astronauts transferring to the Starship, which then lands on the moon. They explore it, live in that huge thing. And then when they get ready to go, they leave, come back up on that connects back to the lunar module. And then the lunar module is what brings them home. Why they don't just use the spaceship to the SpaceX shuttle to do the whole thing, I don't know. Other than maybe because NASA doesn't want to waste all the money that they spent doing this. And they already spent so much money on this Artemis system before SpaceX came around that they're not willing to waste all of that money and engineering and time. But yeah, it's going to be cool being back. I'm hoping that maybe Starship will be built big enough that and get cheap enough that before we get too old, we can actually go take a vacation on the moon. That would be sweet.
I think I'll pass on that. I'm okay with that one.
Oh, I would go in a second. I'd go in a heartbeat if I could take a vacation on the moon. Definitely considering as tall as I am with a bad back, man, that lower gravity. Oh, that'd be heaven. That'd be heavenly bliss for me to be able to have.
I would say we're living in very interesting times because I think 26 states just, it was like 2 weeks ago, they approved the first temporary permits for air taxis. So you're essentially like flying cars, miniature drone helicopter type vehicles. I don't know if you saw that.
I mean, honestly, I think
we first had Waymo, self-driving taxis. Now we're getting, self-driving aerial vehicles. It's pretty crazy.
I think we've been able to have flying cars and flying drones for a while. It's just the fact that they're more expensive and had to be regulated like helicopters and stuff, where now they're getting more to where they're automated and self-flying. So people don't have to actually be able to do it themselves. And they've got so many safety features in them. They have like the automatic land that if something happens, it still has the extra motor to get itself down on the ground and land without having to worry about crashing. But yeah, pretty soon we'll be having flying cars like on the Jetsons.
I mean, we should have some mag rails too. Honestly, I don't know why we haven't made any. But
I don't know why the United States is still one of the only nations in the world not to have a high speed train. I mean, because we can't accomplish any infrastructure projects because all of our GDP goes towards financialization. Or no, because we have dumbass judges like the one that tells President Trump that, he can't build the ballroom because Congress hasn't approved it, even when he's not using taxpayer money and he's using privately raised money and private funds. I mean, it's retarded. And that's the thing that it makes no sense. It's like, why no other president ever needed Congress's approval to do any type of renovations or anything on the White House. They're kind of mad that he didn't go through the Historical Society. But the problem was they probably started working on the inside of looking on the inside of that building and stuff. And then when they noticed the cracks in the foundation and the issues with it that we're not going to be able to, would have cost too much money to be able to get it done anytime near the 250th anniversary or anytime with any type of within budget or within timeline, he figured out the cheapest way to do it was just to totally tear down the old building, which then means it doesn't fall under historical guidelines because it's no longer a historical building. And I mean, that's it's the zoning. He wanted the zoning variances and all the other stuff that he would have needed with keeping that building up. Yeah, it would have been insane. Which I actually had my first zoning board of adjustments meeting last night. But
Go.
oh, it went good. But yeah, so I think we're good when I think it's gonna be hard. I mean, some of the stuff I'm seeing on this, listening to the Supreme Court justice, I'm gonna keep playing the video, but go back to what we were talking about. When I'm reading through these oral arguments, some of them feel like, okay, they're kind of leaning towards, yeah, it's not constitutional, that the Constitution didn't mean for the 14th Amendment to go that far. Other ones sound like they are. It's just so hard to tell because sometimes they'll ask harder questions and stuff just because they want the argument to be just on it, want the argument to be heard. It doesn't necessarily mean that they don't agree with it. Sometimes they'll just ask that question because they feel like that's what somebody who doesn't agree with it would ask, just because they want to hear all sides, or they want to hear arguments from all sides. They really want to make the team that's fighting in protection of it to have to put in more work. I know Justice Alito was well in line with the current birthright citizenship goes way past what the Constitution means, or what the context or the textualization of the 14th Amendment at the time was meant for, or meant to cover. I mean, even looking at the very first justice that talks to him, it looks like he's pretty in line with them. Justice Thomas looks pretty in line with it. So, I mean, Justice Thomas Roberts, let's see what he does. Well, starting with that theory, you obviously put a lot of weight on the subject to the jurisdiction thereof, but the examples you give to support the strike me as very quirky. So Roberts doesn't necessarily seem like he's totally against it, but questionable. Thomas and Justice Alito seem like they're fully in support of it. Obviously, all the liberals are going to be against it. So I guess it really just comes down to, we're going to have to wait till we hear the full actual arguments until we get the ruling on it. As it goes, they were dissatisfied with the potential ambiguity in the phrase Indians not taxed, and they adopted subject to the jurisdiction thereof. And one of the strongest statements of this is Senator Trumbull's statement that I quoted at the beginning, where he says, he's asked, well, what does that mean? Subject to the jurisdiction thereof. So he says it means not owing allegiance to anybody else. That is what it means. Is I guess originally they were going to put Indians not taxed instead of subject to the jurisdiction thereof.
I don't know. I know that lawyer seemed pretty stumped when that question was asked regarding Native Americans and Indians. I don't know if you listened to that part, but that was another.
This is the lawyer talking about it. He goes, so there's a clear repudiation in the Civil Rights Act. The Civil Rights Act is this breakwater, which makes it very, very clear that they are not thinking about allegiance in the terms of like the British common law. They've adopted the Republican conception of allegiance. So it's from not subject to any foreign power. And then the debates just a couple months later make it very clear that they're recodifying the same conception. They were dissatisfied with the potential ambiguity in the phrase Indians not taxed, and they adopted subject to the jurisdiction thereof, one of the strongest statements of which I just read. And this court picked up on that in Elk against Wilkins when it says usage, completely subject to the political jurisdiction, not merely regulatory jurisdiction. So we already know Sotomayor is going to be against it, obviously.
Yeah.
Okay, I'd say two things. First, as to the Indian tribes, we think that's a case that strongly supports us because, of course, by 1866 and 1868, there was strong understanding that the Indian tribes were subject to the United States regulatory jurisdiction. And then Sotomayor, obviously, and goes, I believe you look at the Rogers decision, for example, that we cite in our brief, where they say that they are subject to the United States regulatory. Sotomayor is obviously going to argue against everything. I'm trying to see okay, so here is what you're talking about. First, as to that particular exchange, page 2890 of the congressional record from 1866, Senator Cohen gives this virtually racist statement where he says that. And what does he say right at the beginning of that sort of offensive speech? He says we can't have children of gypsies, children of Chinese immigrants. We can't have them become citizens. And he says, have they any more rights than a sojourner in the United States? So he's trying to persuade the Republicans to his view by appealing to a common understanding that sojourners do not have children who become citizens. So there's powerful evidence there that everybody understood this to, not sweep in the temporary sojourner. And that's why you see for 40, 50 years, you see every commentator who addressed the specific question of temporary presence saying it's not covered by the clause, including for decades after Wong Kim Ark, which is one of the first one. Then Alito goes, General, can I take you back to the Chief Justice's question about the specific expectations to birthright citizenship that everybody seems to agree were recognized under the common law? And it brings up an important principle about how we interpret the law. When particular problems pop up, lawmakers may enact a general rule. When they do that, is the application of that general rule limited only to the situations they had in mind when they adopted the general rule, or do we say they adopted a general rule they meant for that to apply to later applications that might come up? Justice Scalia had an example that dealt with this situation. He imagined an old theft statute that was enacted well before anybody conceived of a microwave oven, and then afterwards someone is charged with a crime of stealing a microwave oven. And this fellow says, well, I can't be convicted under this because a microwave oven didn't exist at that time. And he dismissed that. There's a general rule there, and you apply it to future applications. And what we're dealing with here is something that was basically unknown at the time with when the 14th Amendment was adopted, which is illegal immigration. So how do we deal with that situation when we have a general rule? Yeah, I strongly agree with the way that you framed it there. There is a general principle that's a broad principle that's adopted in the phrase subject to the jurisdiction thereof. And we submit that our theory of allegiance, domicile-based allegiance, is what explains those specific expectations that everybody was aware of, but it is broad enough to sweep in future situations. And as you pointed out, illegal immigration did not exist then. Now the problem of temporary visitors did exist. And it's very interesting that as you look at pages 26 through 28 of our brief, commentators going from 1881 till 1922 are uniformly saying that children of temporary visitors are not included. Now that logic was, say, naturally extends. It's really a forgery case. If you have someone who enters illegally by the 1880s, there are restrictions on immigration. If you entered illegally, it's kind of, a well-established principle of law going back to the Code of Justinian that says you're not allowed to be there. You cannot. You don't have the legal capacity to create domicile there.
Yeah, they were going all the way. They were going back to English common law, Roman law,
Justinian,
yeah.
Which is Roman law, if I remember correct.
Yeah, Eastern Roman. Yeah. Yeah, it's that's where
he even goes back to in ours stating from 1881 till 1922, while we didn't have illegal immigrations, we still had temporary visitors. And at that time, it said children and temporary visitors were not included. So if temporary visitors weren't included, there's no difference between really a temporary visitor and a legal immigrant. So if temporary visitors weren't included in 1922, how in the world is a illegal immigrant's child included in 2026? It doesn't make sense.
That would also apply to people who aren't permanent residents, who are here on temporary visas. So I think that's a good thing personally.
Yeah. Because Trump's argument here is by us having this birthright citizenship, one of the only countries that have it, we literally create people wanting to come here just because they figure that, if my child gets citizenship, then I'll get it. Doesn't mean they will, but a lot of times they feel like them having a child that's U.S. citizen will at least get them to the front of the line to apply for their citizenship. Or that at least their child will have, once their child gets older, they'll have that better life, or the chance of that better life, because they'll try to keep their home because they still have their home citizenship, so their child will still be a citizen in their country if they can't get the citizenship here. But we got to quit, like they say, it's anchor baby thing. It create literally people that come here just to take a vacation just to get that citizenship. It literally makes it pushes illegal immigration even more by offering that argument there. And I agree that we should get rid of it. I mean, it should end. I guess we'll see what happens.
And we're one of the few countries that has birthright citizenship still. So most of the developed world does not at this point. So
yeah, that's what I'm saying is most of the developed world does not have birthright citizenship. We're the only one that does, which makes no sense why we would have it when nobody else does. But I don't know if you heard so yesterday, President Trump signed an executive order. Obviously, it's probably going to be challenged, but it was ensuring citizenship verification, integrity in federal elections. Pretty much what it does is it requires the DHS and everything to work with the USPS. And when the USPS is given the list of mail-in ballots for states to have it mail out for federal elections, that those lists are then matched against citizenship lists, and anybody who is not verified as a citizen on that list, they cannot mail the ballots out to, which in a way is a chain of custody, which I think we still need to fully monitor the chain of custody to ensure that there is no that there is no corruption, like that there is no anything going on with mail-in ballots, because they like to say that, oh, mail-in ballots only show fraud at 0.03003 whatever percent. The problem is that's trusting the Democrats are going to tell you that they're actually going to report stuff if it was to come with that. I mean, that's the problem. It's like, are Democrats really going to tell you when if there's anything coming up that would end their ability to win an election? Are they going to tell you if something happened that would cause the Republicans to take power? Of course not. They're going to hold their power. They're going to maintain their power. And so, I mean, this is a good step. Obviously, if we can get the SAVE Act passed, that's a bigger step. If Watson goes in the favor, which it looks like it will, which is ruling that election day means that you have to have the votes have to be in and counted by election day, or be in to start counting by election day. They can't be received 2, 3, 5, 12 a month or whatever after election day, because that leaves too much room for fraud. I wish other states would do like Texas did and make ballot harvesting illegal. But now
I was watching an investigative report out of Atlanta, and there's multiple churches across from the state capitol that have like 1,000 to 2,000 homeless people using the same church address. So they're just busting people in and paying them to vote. I mean, that's the machine that you saw in Chicago and New York back in the day. So it's not surprising, but it is disheartening. But we are at 1 minute, 5 minutes. We're at an hour and 5 minutes almost. So I've got to start edit out.
Alrighty. Oh, no, it kind of took a little longer on that aspect than I thought of, but I still wanted to show it because obviously that was a historic event that we're headed back to the moon. Couldn't mess the launch.
That was cool. I'm glad we watched it, because I didn't realize I'm glad I was able to get that trail on camera. I saw the tail end of the light, but like right when I went outside, but
wait till the night and go out there tonight and see if you can see the see if the sky lights up blue, because it's something with the chemicals. Pretty late, but it's something with the chemicals and the chemicals and the propellant that like turn neon blue when they light up at night.
All right, I'll check it out. I'll let you know if I see it. I'll take a picture.
Because unfortunately, when I saw it, but this was back before we had the cloud, and so everything on my BlackBerry got lost. This is back when you only had whatever was stored on your phone. You didn't have the cloud and everything. So it's a crazy thing how that was. But all right, man. Well, I'll let you go.
Let me know the statistics. I'm curious.
All righty, man.
All right, peace.
All right, later. Yeah, so all right, guys. I was surprised. Didn't think it would take as long as we did to show that launch. Obviously, kind of went totally off script and we were talking about the case originally, the birthright citizenship, which is what I planned on talking about this whole episode anyways. Couldn't miss the launch of the first moon launch or spaceship launch to space with humans on it going to the moon. Even though we may not land on the moon, we're still making a trip to the moon. And I don't know how many people I've met since started doing, or I've talked to since started doing lives on TikTok and stuff that claim that, oh, we can't even get past the Kepler belt, which they're going to be past that tonight. When they get to their furthest arc on their rotation around the Earth, they'll be past the Kepler belt. They'll be truly in outer space. They'll do one rotation back around, make sure everything's done, and then I think it's by then this time tomorrow they hit their exit trajectory towards the moon. And they're going to have Wi-Fi all the way to the moon, or they should, as long as the deep space communication system works that I think SpaceX has been launching out for a while now. So hopefully we'll see that and we'll end up with some really good coverage on the being able to see from the inside of the space shuttle and see the outside of it. And they'll be able to prove to these people that this isn't something that's being done inside of a freaking Hollywood stage or whatever. Plus, you'll be able to see with the telescope if they never leave the Earth's rotation. Because there's too many satellites up there, and you can, just like you can see the satellites, you'll be able to see this ship because it's got solar panels out on it, just like a satellite. Or it's going to look like a satellite, but probably a little bit brighter because it's actually burning, actually has propulsion going. But so this is going to be, I mean, it's a great time to be alive. Obviously, we got all this technology opening and coming up and some big events going. Obviously, we got all these historic Supreme Court cases going right now that could really help get our Constitution back to originalism and the original intent that it was meant to have. And we'll see how that goes. Like I said, Bost, Illinois is where the court's already spoken. I was going to cover this section, just kind of, it's a small little where I was talking about on Bost. So this is one where obviously the court has already spoken and the impact is instant. And here's why. And it's amazing nobody's really covered a Bost. Bost alters the standing in election law cases. Previously, most challenges required candidates to wait until after the election took place and then demonstrate actual injury, which when you think about it, means you had to lose before you could do anything. And then you had to show harm after that loss, then go to court. And then, so Bost alters that and flips it on its head. After Bost, candidates can prove standing before an election takes place. All they have to do to prove standing is be a candidate by alleging that their ability to win an election could be harmed by the way a law is applied. It's a big deal, and it will make some major changes with how we see Democrats and states run election laws, because that moves election law challenges from after the fact to before the fact. Litigation can occur earlier. Challenges can be raised before votes are cast, and the courts will play a more active role in the election process itself. Supporters of the decision will tell you it strengthens the system. Now, opponents will argue it leads to more litigation, which it could, as long as states aren't trying to change stuff, there won't be more litigation. But regardless of where you stand on the issue, the bottom line is the threshold for entering court has been lowered. So that's what we're going to see with Bost. It's going to have some major effects, some major play when it comes to elections. I mean, and we won't really know until we start seeing the end of this election cycle and see if we truly see any more cases or not. And it's really going to do how much and how often states start changing their election laws. And if they decide to try to wait till right before the election to change laws or something, then we might see this more. But the standings should start helping states to try to change election laws, and it can go both ways. It could help Republicans, it could hurt Republicans, it could help Democrats, it could hurt Democrats. It can go either way. All depends on which state is trying to do what. But all right, so let me try and do one more thing there before I get going. All right, so it's been well over an hour now. We're going an hour and 11 minutes since Joe's gone. I covered most of that, of the space launch. Now it's just kind of showing them getting up into rotation and going around the sun and when they'll get their raise and burn maneuvers. So far they're not really showing any of the interviews of people in there. Really just wanted to carry the launch. Now, as you step away from tonight's argument, take with you this thought. The Supreme Court is simply hearing cases. It's choosing the architecture of our system. Citizenship, who is a member. Watson v. Mississippi, what constitutes a vote and when that process ends. Bost v. Illinois, who can challenge the system itself before it even goes into operation. These aren't incidental questions. These are existential questions that have needed to be answered, because at its core, any constitutional democracy is built on three principles: defined membership, known process, and meaningful access to the courts. If you don't have either of those, then you don't have a democracy. Tonight, the court is putting all three up for debate. That's what makes this term historic. That's why these cases matter as we see this term start coming towards the end. And that's why it's important for you to stay engaged with what the court says and what the court does. Before we go, I want to thank all of you again for joining us tonight on No Kings on the Hill with Dr. Hill Law and Joe St. Clair. If you haven't already, be sure to visit our website at nokingsonthehill with drhill.com, where you can find links to our YouTube channel and all of our social media platforms. Follow us so you don't miss any future episodes. You can also sign up for free access to our weekly blog or choose from one of our 3 subscription levels to support the show. Subscribers get access to our Discord community, opportunities to engage directly with us, chances to be a guest host, and the ability to vote on topics you'd like us to cover next. Also, I want to thank the Patriot Prayer Network for having us. And don't forget to check out PPN. And while you're there, take some time to check out all the other Christian conservative creators on the network. And as always, leave me your thoughts down in the comments. Do you believe the Supreme Court is reestablishing constitutional limits or rewriting them? I want to hear your thoughts. Thanks again for joining us tonight. I'm Dr. Hill, and this has been No Kings on the Hill, episode 26. Stay blessed, stay informed, stay poised, and I hope to see you on the Hill next Wednesday.